SJC-12275, Jane Doe number 1 and others, v. James A. Pizer and others.
Mr. Martin, still morning.
It is, Your Honor. Mr. Chief Justice, and may it please the Court, few things in life are more broadly important than an education. Our Constitution even recognizes that our very rights and liberties depend upon the education of our populace. Yet for years, Boston has been assigning thousands of children to schools that will not educate the majority, and in some cases the great majority, of their students.
Attorney Martin, can I just get you to explain just generally the difference between Horace Mann School charter schools and Commonwealth charter schools, and why Horace Mann charter schools don't fit the bill?
Yes, Your Honor. There are, I would say, three big differences between those two types of schools for purposes of this case. The most important difference is that right now, nobody is trying to expand Horace Mann charter schools in Boston to the same extent that people are trying to expand Commonwealth charter schools.
Is that because of the collective bargaining agreement issue?
Well, there are two reasons potentially why people aren't trying to expand Horace Mann's. Justice Link, you're exactly right. One may be collective bargaining. The other may be that for Horace Mann schools, you need the approval of the Boston School Committee rather than the approval of the Board of Elementary and Secondary Education. For the purposes of our clients who are children in the Boston school system, what's really important is that they simply want to get out of the failing schools they're in and into a school which is much more likely to educate them. Right now, Commonwealth charter operators want to offer them that opportunity.
Commonwealth charter operators are those who don't want to have any interest in dealing with the Boston School Committee or with collective bargaining agreements, right? They're just people who want to operate it in a different way.
Well, Your Honor, they're not our clients, and I don't know why they're not trying to operate Horace Mann
They're the only
schools.
ones who seek to develop charter schools.
There are a few Horace Mann schools in Boston. There just aren't that many. There are, at the moment, 9 Horace Mann schools throughout the Commonwealth. There are 71 Commonwealth charter schools. And when people talk about the wait list to get into charter schools in the city of Boston, it's a wait list of thousands of students trying to get into Commonwealth charter schools, not the Horace Mann schools.
So your complaint is only with the Boston educational system, not with the Massachusetts educational system?
Our complaint is with the 18% cap, which exists as a matter of state law, not Boston
But it's
municipal
only
law.
effective in connection with your clients in connection with Boston.
Currently, Your Honor. It applies to any district which falls within the bottom 10% of school districts. Right now, the only district in the Commonwealth which meets the criteria for application of the 18% cap is the Boston School District, no other school districts.
So it's the cap on the number of Commonwealth schools, or is it the cap on the financial side of it?
Right now, the cap, which is having an immediate effect on our clients, is the 18% cap on enrollment. However, these cases last a long time, and so we've challenged both caps because when this case hopefully ends after discovery in a trial, there's no telling which piece of the cap will at that point be immediately applicable.
And that 18% cap is not the same cap that has been in place since the Education Reform Act was passed. It's been upped considerably over the time.
It has, Your Honor. It used to be lower. It's now 9% in most districts and 18% in those bottom 10% of districts. We'll note, since the question was asked about Horace Mann's, there is no cap on enrollment for Horace Mann charter schools. The key differences between Horace Mann charter schools and Commonwealth charter schools, Justice Link, as you were pointing out, really are who approves them and who oversees them, and whether the teachers who are employed by those schools are unionized and paid union scale or not. The other side's arguments to this court and arguments below really focus on supposed policies which they say underlie the legislature's decision to cap charter school enrollment at 18%. And they say if it goes above 18%, there could be a host of detrimental impacts on students.
Is there any legislative history on how we got to 9% or the number of schools? Or I take it your argument is that it's arbitrary, the number. And both numbers are arbitrary. Do we have legislative history on this, or are we going to have to discern, as the trial judge did, that this is some kind of balancing of interests?
I'm not aware of legislative history, Your Honor. There's certainly none in the record, and the parties don't discuss any. Massachusetts, unlike the federal level, tends to have sparser legislative history, as I'm sure you know.
Yes, we know that.
But what we'll point out, though, is that if you look at the differences between Horace Mann's and Commonwealth's, it really, and this is part of the reason why we say this is an arbitrary and irrational cap, you could have 50%, 60%, 70% of the students in charter schools in Boston as long as it's the Boston School Committee that approves it rather than the statewide board, and as long as they're paid a union wage scale. When you look at the policies that the other side points to and says you can't siphon money out of these existing district schools because there'll be a parade of horribles, well, theoretically, that exact same parade of horribles would apply if the Horace Mann charter schools were taking the money out, because they also draw money from the existing district schools. But the legislature would accept that if the employees are unionized. That is a non-educational criteria. It's exactly the kind of thing that McDuffie and the Hancock plurality say should not be allowed to stand between children and a constitutionally adequate education.
Where does it say that in either one of those cases?
So in McDuffie, Your Honor, we would point to the fact that the court pointed to local control, which under a mere rational basis standard would be a rational grounds for making educational decisions. You can pull that from the U.S. Supreme Court's decision in the San Antonio case. So you have McDuffie saying you can't rely upon things like local control or similarly non-educational criteria to justify a system which leaves thousands of children languishing in failing schools. And if you look at the Hancock plurality, it specifically states that the legislature cannot act in an arbitrary or irrational way, and it specifically calls out in that same portion of its decision the fact that when it looked at the current system, it was not seeing anything that, due to extra educational criteria, was causing children to fail.
So your view is that this court can examine the rationality of every educational decision involving the allocation of money, and that is our role?
No, Your Honor. Our position is that when you have a state statute which is preventing thousands of children from escaping failing schools.
Well, the same could be said about Metco Metco is limited in numbers, and it may be that there can be demonstrable data that show that Metco kids do better than those who are not Metco kids. So we are to say that that cap is irrational, and therefore we're going to require them to expand the number of Metco students? I mean, where does this go?
Metco may be different because that involves education outside the district, and McDuffie was, of course, about education within the district and your right to receive an education in your own district. But we don't think that there are no limiting principles here. And what we would suggest to the court is that you look for some statewide policy, in this case, a cap on Commonwealth charter enrollment, which applies as a matter of state law. You ask whether that's causing thousands of children who might otherwise be obtaining a constitutionally adequate education not to do so. This is not a question of whether Mrs. Smith in 5th grade at some particular school is a bad teacher. Okay, this is a policy which is causing thousands of children to languish in failing schools. And if you see that in a complaint, and if you can see that on the face of the statute, there are arbitrary distinctions being drawn, in this case, for example, between Horace Mann charter schools, which are not subject to the cap, and Commonwealth charter schools, which are, even though the only potential difference between them is the unionization of their employees, that's at least enough to state a complaint. And then we can get into discovery, which was denied to us here, to see whether, in fact, the evidence supports the legislature's decision to place a cap on the particular type of education.
So every time there is an educational decision which a party argues is diminishing the quality of education for some set of students, that can trigger a lawsuit with full discovery whereby we examine the rational basis for that? And the court is going to decide that? I mean, we have the elephant in the room that more than 60% of the voters in Massachusetts appear to have found there to be a rational basis for that. So that's clearly the elephant in this room. How do we deal with the role of the court here?
Your Honor, the Constitution places a duty on the legislature and on the executive branch, which is enforceable by the courts, to provide an education to our children. If the political branches and if the people were actually faithfully executing that duty, then of course the court wouldn't need to get involved. This court exists precisely for situations in which the political process has broken in some way and is leaving thousands of children behind. And that's the situation we find ourselves in today.
Of course, the argument on the other side is that the additional allocation of funds towards charter schools, which, if we accept your proposition, will help those who get into charter schools, will diminish the availability of funds for those who remain in public schools, especially those who may have special needs. And we're going to be asking a court to litigate that after full discovery?
Well, 3 points on that, Your Honor. First, there's absolutely no evidence in the case right now to support that policy rationale that they put forward because we didn't get to discovery. Second, as I mentioned before, you would have exactly the same situation if this was a Horace Mann charter school, which by statute and regulation also pulls money from the district. Yet the state and the legislature are perfectly willing to see the money flow out of the district to the Horace Mann schools as long as the teachers are unionized. We would say that under McDuffie and Hancock, that is an illegitimate basis in which to distinguish between the two types of schools and to allow thousands of children not to receive an education. And then the third point, Your Honor, on that issue is, well, actually, I've forgotten the third point.
Can I ask
First
about
two
the
went on too
standard
long.
the standard review, because these are exceptional provisions, the education provisions. They've generated an enhanced rational basis review, haven't they? I mean, it's not, and you left out the word responsive. It's not just arbitrary, capricious, it's also responsive, right?
That's right, Justice Kafka. It's something more than rational basis.
Yeah, we're not just looking for any explanation. We've set standards, right, and required and concluded they're necessary for an educated citizenry.
That's correct.
So, and we've also in the past had thorough factual inquiries before in Hancock, we had a special master, right?
That's correct, Your Honor. Hancock, as I understand it, was the follow-on from McDuffie. At the end of McDuffie, the court didn't say, as the other side sometimes suggests, executive branch go off and fix this. McDuffie ends with this court saying, at least for right now, we'll give the legislature the first crack at fixing this, but the Superior Court can maintain jurisdiction over the case to make sure that adequate process is being made in a reasonable time. That led to the Hancock decision.
Hancock, we have some failing schools in Hancock, right? The court, we even have failing school systems in Hancock, and the court says, we're still not going to intervene. That's where I get confused by what we're supposed to do here.
So what happened in, the way we read Hancock is that the court, throughout that decision, pointed to progress that was being made and referred to a steady trajectory of progress in the schools, so that even though at the time their MCAS scores may not have been that good, they were much better than they had been in years prior. And the court expressed optimism that based on that trajectory of progress, the state might be able to meet its goal, its then stated goal of having all children be proficient in the MCAS tested subjects by 2014. It's now 2017, and as we've pled in our complaint, for the last 5 years, the schools in which we focus, at which these plaintiffs attend, have not been improving. In fact, in many instances, they've been backsliding.
Well, wasn't that true also in Hancock? I mean, if you look, Hancock is hardly a univocal decision by this court, a unanimous decision by this court. You had several judges who aligned on the result, some of whom felt, well, given the progress that's being made, we're not going, we're going to look at the progress rather than the effects. Two of the judges felt that we should never have gone as far as we did in McDuffie anyway, so they were happy to not say anything more in Hancock. And only two justices who were in dissent said that you don't do it by looking at what progress has been made in terms of aspirations. You look at it in terms of effects. And certainly there was failing schools at the time. I did not see this as in essence. I mean, if Hancock was McDuffie 2, I don't really see this case as a McDuffie 3. Do you?
We see it as in some sense, Hancock 2. So the Hancock plurality said, as we examine the record, we see a steady trajectory of progress, and we do not see anything that's been pointed out to us by the plaintiffs in that case as being arbitrary, irrational, or non-responsive. We are now taking the language from the Hancock plurality and saying that if you look at the fact that thousands of children are in schools that aren't improving, and if you look at the fact that the legislature would let them escape to some other type of charter school that's unionized, but not a Commonwealth charter school because it's not, that that's an arbitrary and irrational response to the fact that these kids are more likely than not, and in some cases much more likely than not going to be educated by the schools they're in.
How does the proposed solution, lifting the cap, actually solve the problem? Because you're always going to have some number of students who can't get into the charter schools and are left behind. So just, you have a very specific remedy you're looking for, and I'm just trying to figure out how it solves the problem.
And so, Your Honor, it will solve the problem for many thousands of children. We don't know if, for example, all the children will wind up being educated, but for this plaintiff class, their odds of actually getting into a charter school will be much greater than they are right now subject to the cap. And there are also dynamic effects. I'll note that even with the cap, there were applications for more than 2,000 seats, additional seats at Commonwealth charter schools during the year we focused on in our complaint. If there were not a cap, it may be that Commonwealth charter school operators would have filed more applications for more seats, but they were dissuaded from doing so because they knew the cap was in place. So we're hopeful. We're hopeful that if the cap is lifted, then supply will come forward to meet the full demand. But we already know that there's lots of supply that will meet a significant portion of the demand.
Mr. Martin, let's just assume all that's true. I have a separation of powers question for you, an Article 30 question for you. So let's assume for the purposes of my question that if you eliminate the cap, you're going to improve to some percentage, to some degree, the quality of education, certainly as it relates to your clients and perhaps as it relates to some municipalities. But do you have to show with McDuffie, do you have to show some sort of systemic deprivation going on before the court starts micromanaging these, what seem to me to be really important policy decisions?
We do agree there needs to be something systemic. We don't believe it needs to be a complete statewide breakdown, as the Superior Court suggested. In this case, we think it's sufficient for purposes of showing some systemic problem that the legislature has put in place an arbitrary cap on one particular type of charter school. And as a result of that, there are thousands of children who could be educated in a more constitutionally appropriate fashion who will not have access to that education. Also, as to separation of powers, I would note two things here. We know the legislature would be perfectly fine with far more children being educated in charter schools as long as they were Horace Mann schools with everything that comes with Horace Mann schools rather than Commonwealth charter schools. So we do not actually have the legislature saying 18% and no more. We have the legislature saying 18% as long as there's local control and a union involved. Second, if the court were to strike down the charter cap, it's not the court that will wind up deciding whether additional charter schools will be approved in the city of Boston or potentially elsewhere. It will be the Board of Elementary and Secondary Education. It will be the executive branch. And we know that the Constitution places the duty to educate children on both the executive branch and on the legislature, not the legislature alone. This isn't the U.S. Constitution with certain powers given to Congress. What we're really asking here is for the court to strike down an arbitrary limit that the legislature put in place so that the executive branch can do its job and can look at these charter schools on a case-by-case basis and decide whether to authorize more schools and more seats in charter schools in the city of Boston based on the education-focused criteria that are set forth in Section 89 and in the Boards of Elementary and Secondary Education's regulations. It can focus on those education-focused criteria, not an arbitrary 18% formula.
You hope the discovery will show? What types of additional facts are you trying to develop that the cap is related to collective bargaining and not education? I'm trying to understand what you're hoping this discovery is going to establish, because it does seem different from Hancock and McDuffie. McDuffie, we had stipulated facts, and Hancock, we had a lengthy investigation. But I'm trying to understand what discovery is going to show here.
And so I expect what discovery will show in this case is that the cap is not supported by the policies that the defendants have put forward as supposedly justifying the cap. We already know from the face of the statute that the cap, we would say, is irrational to the extent that it prioritizes unionized charter schools over non-unionized charter schools. To the extent the defendants say it's also supported by a variety of other policies, we expect to disprove those. In a way, it would make this case somewhat similar to the way even rational basis review was conducted in the Goodrich case, where a number of potential justifications for the policy were banning same-sex marriage were put forward by defenders of the policy in that case, and the court kind of set them up and knocked them down. We hope to do the same thing in this case with respect to the policy rationales for the cap that defendants have highlighted.
Counsel, you say that the percentage is arbitrary, it's an arbitrary number. Aren't you saying, though, that the cap in and of itself is an arbitrary distinction and it should be completely eliminated? Because the legislature passed a law saying, okay, now we're going to go up to 25 or 30 or 40 or 50%. Wouldn't this arbitrary argument still apply?
It would. To some extent, we think ideally you would allow the executive branch to approach this always on a case-by-case basis. It could be that a cap which is properly formulated based on the evidence could survive some level of review, but that's not what we have here. And I hate to keep going back to the example of the Horace Mann schools, but you have the legislature saying as much of that kind as you want, but no more of this kind. We think it'll be hard for that to survive review by the courts.
So are you basically saying that even if there were no Horace Mann schools as an alternative, the cap would still be irrational?
We believe at the end of the day, Your Honor, we would be able to show that it is, because those other justifications that have been put forward by the defendants will not be supported by evidence.
What other justifications are those?
Well, the arguments that, for example.
On game, for example?
Yes, Your Honor.
That's not so? That's not immediately evident? That it's, unless funding gets improved?
Well,
There's only so much money to go around?
it's less funding, but it's also far fewer students. Right now, you've had more than 10,000 students withdrawn from the Boston school system as a result of the charter school system. And so there could be some rationalization which goes on there. That's not the kind of thing which is immediately apparent. It really does need some evidence to backstop it.
Now, in McDuffie, the order ultimately said, it is the responsibility of the Commonwealth to take such steps as may be required in each instance effectively to devise a plan and sources of funds sufficient to meet the constitutional mandate. It was ultimately about state money being furnished to the schools in poorer communities. This is different. So if you prevail here, finish this sentence for me. While the court in McDuffie and in Hancock was focused on the adequacy of state funding for poorer communities, the court now has declared that it is an appropriate role of this court to.
It is the appropriate role of this court to ensure that the legislature and executive branch are exercising proper oversight of the local school systems, and where appropriate, supporting policies that will make sure that every child in every one of our communities is educated. And I think Your Honor needs to look not only at McDuffie and Hancock and the particular concern in that case, but if you read back through the extensive historical analysis in McDuffie, it makes clear that for over 200 years, the legislature, and to some extent the courts, when these cases have come up to the courts, have looked at how individual school districts are educating or not their children and stepping in when there are problems. So one of the cases from the 1800s, for example, dealt with a particular town that was supporting one type of school in one part of town, but not a different type of school in another part of town. And the legislature and the court said, no, the state's authority and duty to make sure that all children are educated requires that and supports the legislature stepping in to ensure that every child in every town is educated.
Okay, thank you.
Thank you, Your Honors.
Mr. Toon?
Good afternoon, Chief Justice Gantz, and may it please the court. Robert Toon for the Commonwealth Defendants. I'd just like to note that we've allocated 4 minutes to Ms. Allison, counsel for the NAACP, and others. There is an important and ongoing debate in Massachusetts about the future of charter schools versus traditional locally controlled schools. This debate involves families, teachers, business groups, civil rights groups, education reformers of all stripes. The plaintiffs here are fully entitled to participate in that debate and advocate for further increases in the current limits on Commonwealth charter schools. But they may not, I'm sorry, Your Honor.
Let me just ask you, your brother said that there is no legislative history as to the caps on charter schools.
Well,
Know anything about how it is that, what charter schools were supposed to be about and why they were in the legislation and the Education Reform Act to begin with, why it is that the caps have gotten changed over time? Do we have anything on that telling us what the legislature was thinking?
Well, the statutes themselves say quite a bit. I mean, the 1993 Reform Act states that the purposes, gives several purposes of charter schools, including to develop innovative programs in the Commonwealth schools as a whole. The charter school statute has been amended 13 times since 1993, and the caps have been increased steadily, most recently with the 2010 Achievement Act gap, which raised the cap for Boston schools, since they're in the lowest 10 percentile of performance in the state.
Which way does that cut? Because it sounds like, I mean, in 1993, they provided for like 12 charter schools or something, really small number, right?
I don't know the exact number, but now we're up to 120 schools, actually quite a few more than that.
So does that suggest that the cap was too low when we started, or is it suggest that the cap is right to be adjusted? I mean, if without any legislative history, how they pick those numbers, how do we make that decision and conclude it's appropriate, I guess?
Well, Your Honor, I think it shows that the fact that this cap has been amended so many times, the legislature has responded to calls by reformers to increase the amount of both Commonwealth and Horace Mann charter schools in Massachusetts. But fundamentally, what matters is that the Education Clause does not allow for the kind of relief that the plaintiffs seek here. And they said that we're trying to distinguish or limit McDuffie and Hancock. That's not the case. We rely on McDuffie and Hancock. And there's a straight line from those decisions through a decision of the Superior Court below. McDuffie and Hancock stand for two basic principles. First, the courts have a vital role in determining whether the Commonwealth has met its duty to provide for the common right of education. But second, decisions about the details of educational policymaking are vested with the elected branches, with the governor and the legislature. In Hancock itself,
But
plurality...
isn't there a third principle that we're not going to let disadvantaged school districts or disadvantaged groups of students continue to be undereducated? I mean, there's a third part of McDuffie, and also even in Hancock, where we're very focused on leaving groups of disadvantaged students or groups of disadvantaged schools unattended. Isn't that a big part of McDuffie and Hancock, and also the litigation that's happened around the country on these state education clauses, right?
Well, certainly McDuffie and Hancock have had tremendous impact on how our education system works today. That's why we are, by all accounts, recognized as having the strongest such system in the nation. But they are not stating a McDuffie 3 or Hancock 2 type lawsuit. They don't allege the basic elements of an education.
But they're identifying a group of disadvantaged students who are not getting full opportunities. Whether it's the facts are going to bear this out, I don't know, but they're suggesting, like McDuffie and Hancock, there's a group of students that we can't keep letting be undereducated. That's what they're saying, right?
McDuffie involved 16 cities and towns across the Commonwealth with a detailed examination of the deficiencies in those schools. And the court in McDuffie identified a failure of the Commonwealth that caused those deficient school conditions. What do we have here? There are non-conclusory allegations focused on 5 unnamed public schools in Boston, 5 out of 118 total for Boston, out of 1,850 for the Commonwealth as a whole. All we know about the schools are their poor test scores and their level 3 and level 4 classifications as a result.
Well, wouldn't we know more if discovery were permitted?
I'm sorry?
Wouldn't we know more with discovery?
Well, they have a duty to state a plausible claim at the outset before we go to the discovery phase. And we don't think they allege a systemic deficiency in the schools, and they don't identify any failure of the Commonwealth that causes those deficiencies. The only state policy they identify is the current cap on Commonwealth charter schools. But they admit that that cap has no causal relationship to these supposed deficiencies in their assigned public schools. There is no allegation of a failure of the Commonwealth that has caused the conditions in these schools. Instead, they're using sort of the barest bone skeleton of a education cause claim in order to attain their specific educational policy that they desire. But that's not what the education cause is about. In this court in Hancock, I'm sorry,
So what
Your
would
Honor.
a McDuffie 3 suit look like that this is not?
It would involve allegations about a widespread deficiency in the Commonwealth that is shared more than just a handful of schools in one district. And it would involve a allegation of something that the Commonwealth has failed to do. In McDuffie, it was the inadequate financial support that the Commonwealth provided. But it could be other issues as well. And there has to be a causal...
Not just the executive and legislative branches you're talking about that have failed to provide? Or was it in McDuffie that it was because of the tax, property tax?
It was,
related?
I think it was the system of financial support that was provided by the legislature
All right.
as a whole. So there has to be a failure on the part of the Commonwealth that causes a widespread deficiencies in the schools. And we don't have any of those elements stated here. Just to circle back to the plurality decision
What sentence in either Hancock or McDuffie says that it has to be a widespread failure, as opposed to if you neglect a particular group or a particular group of schools, that's not enough? Because my understanding in Hancock, the court was also confident that the state was addressing the underperforming schools, or at least making every effort they possibly could to do so. I just don't know about this widespread, or the language used by the trial judge about sort of complete abandonment.
That's the language from Hancock. It's an egregious statewide abandonment of the duty to provide for common right.
Hancock-
And it's a common right of education, Your Honor. This court held in Dell versus Superintendent of Worcester that it's not an individualized right. It's a right of the common right to public education. So we think that's clear. There has to be some kind of failure that is widespread. Here, of course, plaintiffs are only focused on Boston because Boston is the only school that has reached the funding cap that they seek to challenge. But that's not a basis for an education cause claim. They are just trying to use the education cause claim as a device to get to their chosen policy remedy. And this court in Hancock said you just can't do that. It used the example of preschool for at-risk children. The court said that's not an acceptable remedy for the judiciary to order. It's not that it's a bad policy. It might well be a terrific educational policy. But the court explained that each such decision necessarily embodies a value judgment, imposes real and immediate financial costs, and ultimately is a fundamentally political decision. The order that the plaintiffs seek here, eliminating all limits on Commonwealth charter schools, would necessarily embody value judgments about the relative merits of charter schools versus traditional district schools. It would impose additional supervisory costs on the Commonwealth. It would further reduce funding for traditional district schools. And I think most importantly, it would inject the judiciary into something that is one of the most fundamentally political debates of our time.
The judiciary has been injected into the education clause jurisprudence well before Hancock. You know, it's been around the country. I'm heavily involved in this because, again, it's an enhanced rational basis review. It's not the ordinary deference because it's deemed so essential to an educated citizenry, right? We've passed that threshold, haven't we? The issue is how much deference is owed, right?
I think the question is, when the plaintiffs seek only one particular policy remedy, is that appropriate for this court to engage and say, yes, we'll consider that? Because if they can do that based on these allegations, then opponents of charter schools can file the very same lawsuit and seek their remedy. Or people who advocate longer school days or shorter school days or higher teacher salaries, everything is going to be up for grabs. If the court
That's a serious concern. That's a serious separation of powers concern, but that's really not their argument. What their argument really is that a charter school cap is arbitrary, it makes no sense, and kids are not being educated adequately because of something that, from an educational perspective, makes no sense, such that kids are being deprived of a quality education under the Constitution. That's their argument.
Well, I don't think that's a plausible argument to say that a cap on charter schools is irrational. It serves many purposes. It clearly preserves local democratic control over schools. It preserves a baseline funding for traditional district schools. It preserves the resources that are to be expended by the board and the department in overseeing and supervising charter schools. It mitigates against the risk of charter schools that fail, which impose substantial costs on families in the Commonwealth.
Well, they'd say, yeah, maybe, but let's have a discovery and see whether or not these education deficiencies imposing a cap on charter schools is just arbitrary and makes no sense. I mean, that all may be true, but they're saying, let us have our discovery and then let's have the argument.
Our argument, Your Honor, is under 12b-6, and we have standing arguments that are separate. Under 12b-6, if they cannot state the elements of a claim, they don't get to proceed to discovery. And in addition to that, with respect to the education clause, they are specifically asking for a remedy that this court held in Hancock was not available under the education clause cause. And I can address
What remedy would that be?
I'm sorry?
I'm sorry, could you just expand on your last point?
Yes, I mean, this is the ruling the plurality that the point about preschool for at-risk children. That regardless of its merits, that is the kind of remedy that the courts may not impose, even if there were to be an established education clause claim, which we don't concede one was alleged here. And I think in McDuffie, too, where the court did find a violation, its decision was, well, we're going to defer to the legislature and let them
But they
determine
also
what the
gave
remedies
the
are.
7 standards, right?
I'm sorry?
They referred to the Kentucky Supreme Court. They identified 7 types of standards that the legislature should look at. I mean, it wasn't just a wholesale do-over. It was a do-over with some guidance, wasn't it?
It was, and there's certainly a lot of guidance in the decision. But again, Your Honor, they don't come anywhere close to stating a McDuffie 3 type lawsuit here. It is really the barest bones allegations of 5 unnamed schools in Boston. If that's enough to get anyone through the door, then any policy advocate is going to get through the door. They have to do much more. These plaintiffs and their lawyers know how to do a McDuffie type lawsuit. That's not what they're doing here. They want to strike down the cap on charter schools. And our point is that the education clause claim and the equal protection claim are not viable vehicles for them to achieve that.
Can you
goal.
address their argument that there's no rational basis for allowing Horace Mann schools to increase, but not the Commonwealth schools? Particularly, the Horace Mann 2 schools are the ones that you need a vote of the existing faculty to approve. Is that right, or is it the 3? I can't remember.
Horace Mann 1 schools, all Horace Mann schools require the approval of the school board. Horace Mann 1, I believe, also require approval of the local collective bargaining units. 2 and 3, Horace Mann 2s and 3s.
So address their argument that, okay, why are you allowing those to increase and not the Commonwealth schools when the Commonwealth schools have a successful track record? Why treat those 2 groups differently? What's the rational basis for
Well,
that?
let me first say, Your Honor, this is an entirely new argument. It was not raised below. It was not raised in their briefs in this case. So I'm addressing it for the first time. The fact is that the legislature created 4 different types of charter schools, and some have been more popular than others. But the fact that there is remaining availability for Horace Mann 1, 2, and 3 schools does not mean that they are cutting off availability for...
But there's a difference. For example, the second type of school, I take it you convert the existing school with the existing faculty into that school, right? And there's no problem doing that. But there is a problem, and so you can increase the numbers to do that, but you can't increase the numbers to create a Commonwealth school. What's the logic in that in terms of the justification of allocation of dollars and other things? I'm just trying to understand it.
Right, and I guess if we had more time, because this is an entire new theory that we've never heard
think they're
before,
gonna
their
give you
equal protection
time.
claim is not premised on the difference between Horace Mann schools and Commonwealth charter schools. They don't even mention Horace Mann schools in their complaint.
Right,
So,
but we're asking.
okay, then I think that, again, it's difficult. These are just different modes of charter schools that have been authorized by the legislature.
Well, they're suggesting that it has something to do with collective bargaining and unionization. I don't know if it's true or not, but that's what they're suggesting, and that they'd like discovery to make that connection.
To back up, the presence or absence of collective bargaining rights, we don't see how that in any way relates to either of the constitutional claims they're asserting here.
Well, I think their argument is that that's That's the arbitrariness, that it's essentially opposing forces in the collective bargaining arena are dictating the number. I think that's their argument. I'm not positive, they haven't come right out and said that, but that seems to be what they're arguing.
Well, under the current cap, I believe up to 78 Commonwealth charter schools are allowed, 72 places are allowed for Commonwealth charter schools, and 48 are allowed for Horace Mann schools. So many more Commonwealth charter schools are allowed under the current system of the current cap. And again, in 2010, the legislature drastically expanded availability for Commonwealth charter schools in places like Boston. They're in their lowest 10%. So it's really hard to see any kind of animus towards Commonwealth charter schools on behalf of the legislatures as they've continued to expand availability for these types of schools. And I just want to reiterate, this argument has never been made before. Our point about Horace Mann schools is that if the fact that they cannot account for the broad availability of Horace Mann schools, you could add 39 Horace Mann schools in Boston tomorrow, we don't see how that allows them to have a legally cognizable interest that isn't already resolved by what the cap currently allows.
Okay, thank you.
Thank you.
Ms. Allison?
Good afternoon, and may it please the court. The plaintiffs do not speak for all students in Boston Public Schools. I speak here today for the NAACP, the Boston Education Justice Alliance, and some of Boston's most vulnerable students who would be harmed by the expansion of charter schools. Thank you for the opportunity to be heard. The plaintiff's claim necessarily elevates the interest of students who wish to attend charter schools over the interest of students who charter schools do not adequately serve. That result would be inconsistent with both the Education Clause and equal protection. The plaintiffs can't state an Education Clause claim under any standard. There are at least two fundamental principles in McDuffie. First, that the Commonwealth has a duty to educate all of its children, and second, that it must meet that obligation through a guarantee of adequate funding. The plaintiff's claim cannot be squared with either of those principles, and discovery will not change that. Under the
So in
statute—
Equal Protection Clause, you need to have some discriminatory intent, don't you?
Under equal protection?
Right.
Yes.
And that hasn't been alleged, has it?
That has not been alleged. And now, as to the Education Clause, every dollar that goes to charter schools is diverted from traditional public schools, with only limited and uncertain opportunities for reimbursement. So there can be no genuine dispute that that funding mechanism, as it exists in the statute, makes it more difficult for already struggling traditional public schools to educate their students. That harm is mitigated to some extent by the cap, but the plaintiff's demand for an unmitigated diversion of public funds to Commonwealth charter schools undermines the central tenet of McDuffie, that all children have to be guaranteed adequate funding for education.
But are they saying, I mean, I understand they want to open the cap completely, but they're saying that the governmental action here, which is putting those numbers on the cap, are irrational, right? Or non-responsive to the need of that community. They're making a narrower argument, aren't they? I mean, I understand your point that if it's unmitigated, but they're just saying the number you picked is really not responsive to the problem.
Well, but the remedy that they seek is a removal of the cap, which would allow the expansion of charter schools to be unmitigated. They notably don't take...
In McDuffie, you can declare in McDuffie, they declared the statute unconstitutional, but they didn't impose the remedy the plaintiffs asked for. They left that to the legislature and the executive, right?
That's precisely right, and their claim is fundamentally inconsistent with McDuffie because it would require not only imposing a remedy, but imposing a remedy that would injure other students in those struggling schools.
Now, you might be right, but their response would be, you might be wrong, and they should get discovery in order for a judge to make an informed determination of that based on a more fulsome record. What is your response to that?
They don't claim, and it would not be plausible to claim, that charter schools is the constitutionally required remedy for the ills of every student in a struggling district school. That's simply not a plausible allegation, and that's what the plaintiffs demand here. They don't simply seek a determination that their schools are inadequate. They allege that, but that's not where their complaint ends. They demand that the remedy be more charter schools. The court would not be responding to their claimed injury unless it allowed the expansion of charter schools. That's not a plausible allegation under McDuffie. My clients are the prime example of the backwards nature of the plaintiff's claim.
Can I ask, so what if the legislature eliminated charter schools right now? Is that fine too? Could they just, even though we know that they're providing some very valuable benefits to students, can they just eliminate the charter schools?
If the legislature eliminated the charter schools.
Knowing that some of them are doing a really good job, can they just eliminate them?
Well, as the Attorney General has argued, McDuffie makes clear that these sorts of policy judgments first belong
But there's
in
a
the
limit.
realm of the
There's a
legislature.
limit, right? It's cabined somehow. The education clause is different. We have an express constitutional provision providing a right. We're not doing ordinary rational basis review, right? So there's some cabining. So do you think they could eliminate charter schools or lower the numbers?
No, I agree that this court has a duty to determine whether the act of a legislature is constitutional. And there would be, a genuine question if a successful educational initiative was completely eliminated. However, the court then faces those separation of powers concerns.
But isn't this a
Whether-
variant of that, whether the number is appropriate? It may be different. I understand it's different. But, at one point there were no charter schools, or 12 or 24. I can't remember the original number. It's gone up, so is the percentage. I'm just trying to understand, there's a certain point where you have to protect this. I don't know whether you have to enhance it, but doesn't it become non-responsive at a certain level to pick the wrong number?
The plaintiffs do not plausibly allege that the limitation on charter schools is irrational, given the history of the statute.
Well, they do, whether they're right or not, but they certainly suggest that parts of it are irrational. They're saying that the 9% up to 18%, and the number is not responsive to the issue.
The purpose of the cap is to ensure adequate funding for traditional public schools. That's baked into the statute. That's why the ceiling was created. So a cap on the number and funding in particular of charter schools is well suited to ensuring that the traditional public schools are adequately funded. And over the years, that cap has been closely evaluated and debated. Both the numerical cap and the funding cap have been overhauled 4 times. You've heard that the statute itself has been amended 13 times. The legislature has paid careful attention to this issue, but it has paid careful attention in particular
So you're
to
saying
the
it's
cap.
like Hancock. You're saying that even though there's a problem out there, the legislature has been responsive and upped the number of charter schools in response to the problem. Is that what your argument is?
I'm saying that the legislature has been responsive to the desire for the charter school experiment. Unlike, in Hancock, the allegation was that, that the adequate funding for all children's education required by McDuffie had not been achieved. Hancock was not looking at a particular initiative and said that it shouldn't.
I'm just trying to, in Hancock, we say that even though the schools are underperforming dramatically, there's been enough improvement and enough attention and enough evolution that we're not going to intervene. It sounds like that's what you're saying here.
That has happened in the case of charter schools. I agree with that.
But you're not suggesting that if there were no state statute providing for charter schools, that there would be a constitutional entitlement for us to create that?
There would not be a constitutional entitlement for you to create that.
Ms. Allison, you came here representing clients, and you haven't been able to get out the impact on your clients. Can you take a minute to at least have a chance to do that?
Yeah, thank you. My clients believe that they are the prime example of why this case would turn McDuffie on its head. Data collected shows that my clients, English language learners, students with disabilities, students of color, are largely underserved by charter schools. You know, McDuffie cannot be read to allow a result that would doubly injure the Commonwealth's most vulnerable students. First, by stripping funding from their traditional public schools and then providing them an alternative that is inadequate.
Is that because of any reason why? I mean, I thought it was a random, anyone who applied was put into a random pool of whether or not they got into a charter school. Why is it that your clients are more affected?
My clients would be more affected if the cap were lifted, because charter schools do not adequately serve the highest need students like my clients.
But how do we know that?
Data has shown that. Again, the court doesn't need to find that the plaintiff's claim should be dismissed. What the plaintiffs are claiming is not simply that they are subjected to inadequate schools. What they are claiming is that there is a particular remedy that must be granted in order to address that injury. And it's just not plausible that that particular remedy is going to address the concerns of every student at those suffering public schools, including students like the clients I represent.
Okay, thank you.
Board, all rise.